Steph has 22 years legal experience, and prior to joining forces with Joanna, she practiced as a sole practitioner for 6 years. Previously worked for Russell McVeigh Wellington as a Crown Counsel in the Employment and Education team of the Crown Law Office, and as an employment lawyer for the Human Resources Specialists Right Management, formerly known as Green Hanson and the Empower Group. Steph is a founding member of the Social Workers Disciplinary Tribunal, a member of the New Zealand Law Society Wellington Branch Council, and was a founding author of Brooker's District Court Procedure. Steph is a member of the New Zealand Law Society and Wellington Women Lawyers Association. She's recognised as a highly effective senior employment advisor and advocate, and is a skilled conference and workshop presenter, and has developed a specialist expertise in undertaking independent investigations and review. Her talk today is entitled "Why Equal Pay is So Important for Low-Income Women." Please welcome Steph in the normal manner.
Thank you, Peter, for that introduction. It's amazing how good your CV sounds when you write it yourself, isn't it? Feels like I've been around for a long time. That one must be a little out of date, I think, because I think it's more like 25 years I've been practising law. And the thing that is noticeable, I think, now in the practice of law is that when I was first admitted to the bar in 1990, having worked at Russell McVeigh for a summer and things, there was a study that came out just after our admission. We just started work, and looking around the room, this might resonate with a few of the other women here, which is that there were very, very few women who were staying in the practice of law after 10 years. And so there were a lot of women coming out of law school and being admitted and working. And then after about 10 years, they sort of all disappeared off. That has been reversed significantly. I'm now one of a large cohort of women with 20 years plus experience in the law. A lot of them now are partners in law firms, have started their own practices, as Johanna and I have done, are judges, tribunal heads, commissioners, ombudsmen, all those sorts of roles. And so that has been a big change for my profession. And I suppose professional women often end up focusing a lot on their own navels and their own best interests in trying to break through glass ceilings. But the thing that has struck me in the last 2 years has been really how far behind women are who are not as privileged as I have been to come out of the lower echelons of society and come into the professions. And that for those women who have not had the opportunities I've had in terms of education and professional development and income earning, the story is still very, very different. So that is the background to what I'm going to talk about. So thank you for the lovely lunch. I wrote that before coming here today, and I'm glad that it was true. And thank you very much for allowing me to talk about something that is a topic close to my heart, and particularly because of my recent involvement, our firm's recent involvement, in a landmark equal pay case. So I'm going to talk a bit about that case and what it means, because it got quite a lot of publicity and may still get some publicity. And a lot of people don't really know what it's about, so I will talk about that. I'll talk about the history of equal pay in New Zealand a little and what led to the Equal Pay Act 1972, and then the impact, the disproportionate impact that the issue of pay inequity has on low-income women. So that is what I'm going to talk about. Hopefully that is what you want to hear about, and if there is time, I would welcome questions from the floor. Last year I was privileged to participate in the Equal Pay case, which was a case taken by the Service and Food Workers Union on behalf of their members who work in rest home care, caregivers in rest homes. And one woman in particular, a delightful woman called Christine Bartlett, who'd worked for Terra Nova and its predecessor companies for over 20 years. Fabulous woman, coming into her 60s, very lively, very vivacious, very caring, and had been a caregiver for a very long time, and earns $13.85 an hour. So Christine and her co-workers felt very strongly that their pay rate was lower than it would be if the care of the aged had not traditionally been the work of women. And they believed that this was a pay equity issue. And so the lawyer who led the charge for the Service and Food Workers Union, Peter Cranny, who's a very able litigator of this fine city, took up cudgels, and I assisted him with that case. and that was a case about pay equity or equal pay for work of equal value. So it was about the interpretation of the 1972 Equal Pay Act. That was a piece of significant social justice legislation, and some people in this room look like they're probably of a vintage to remember these days well. This abolished differing rates for the same work paid to men and women for no reason other than gender. And so up until the Equal Pay Act in 1972, in the private sector, it was completely lawful to discriminate between what you paid men and women solely because they were men and women. The public sector had already been regulated in a previous act, which abolished differential pay rates for the public sector, and the private sector followed. And there was a background to this, and this is based on a lot of research. Everything that I say today is my own opinion, but there is a lot of research behind the things that I'm talking about. I had to read boxes of stuff that have been lovingly kept for many, many decades by people. Particularly in the post-World War II years leading up to the 70s, the male-dominated union movement and the award system had entrenched the practice of paying women less for doing the same work as men. In part, I think it's pretty clear that this was patch protection, keeping jobs for male union members and preserving what was seen as proper relativities. Some of this was after the war, when men came back from fighting and were coming back into jobs which women had carried out in their absence. And at that time there was often a noticeable shift in attitude of the union movement to preserve jobs for their members coming back from fighting. Some jobs evolved. Traditional male roles such as clerical work. Secretaries were originally men because women didn't tend to work outside the home, and that job shifted over the years. It became feminised and then it became a low paid job, but originally the union movement was quite strong in trying to keep the rates up for those jobs, but then there was an abrupt change of heart when in 1945 the attitude towards then paying women less for doing clerical work. So there was shifts over time in the nature of work and the pay rates for it, but what became fairly entrenched in the award system was that people doing the same job would be paid differently based on gender. Regulations and awards also excluded women from certain work or conditions. Heavy lifting, dirty work, working with toxic substances and so forth, night work. There were a lot of assumptions that meant that that was regarded as unseemly or inappropriate work for women, and so they were by regulation prohibited from carrying out that work. That work, of course, was hazardous and dangerous and could harm your health, but it also paid significantly more because there were allowances that went with it. Women doing what was regarded as women's work were paid far less than what was paid for what was regarded as traditionally men's work, and that is what I'm talking about principally today. So work that has traditionally been carried out by women almost exclusively or predominantly. Those distinctions in pay rates based on gender had evolved out of custom and practice, but they were actually enshrined in New Zealand law and the approach of the arbitration court for a long time. There was a commission of inquiry in the late 60s and early 70s. This came onto the agenda, a commission of inquiry into equal pay in New Zealand. And it determined, after hearing an awful lot of evidence from people all over the country, that the distinction between what men and women were paid was based on traditional assumptions about a woman's role in the family and society. The Commission considered and rejected the employer lobby's argument that the economy, the New Zealand economy, could not afford to pay women what their work was really worth. That was expressly considered and rejected. Eliminating gender discrimination in pay was seen as a significant human rights issue. It was seen as something that was holding the New Zealand economy back from growing, and it was necessary because New Zealand had ratified international conventions, ILO and other conventions, about the elimination of discrimination on the basis of gender. And for New Zealand to comply with those international conventions it had ratified, there had to be a significant change in legislation to abolish those differential pay rates based on gender. The report of the Commission records that it accepted evidence presented to it, which clearly established that what were regarded as jobs utilising womanly talents, delivering babies, caring for the young, the sick, the elderly, the dying, cleaning, doing laundry, cooking and sewing, those sorts of tasks were undervalued because they were seen as merely reflecting women's nurturing natures and the knowledge they acquired growing up and running a home. Because this work within a woman's own family or home was performed for free, it wasn't properly valued when it was performed for other people for money. And so when that work went from the domestic sphere to being a job, It was just seen as women's work, it was less valued, and it was paid accordingly. The work was essentially regarded as requiring no real skills or training. Work performed by men, on the other hand, often required completion of an apprenticeship or other vocational training, generally outside the home, or it was professional work able to be performed only after obtaining a higher education long denied to women. Semi-skilled work or manual labour had traditionally been more highly valued when it was men's work, even where the effort required and the conditions endured could be said to be comparable to work done by women. Anyone who's ever worked in a commercial laundry, for example, will attest to the fact that that is easily as hard as labouring all day in a ditch. Hard physical labour in difficult or dangerous conditions has always been undertaken by both sexes, but if men were doing it, it was regarded as deserving more money. And it just was. This is self-evident. It was always remunerated far better. Even where men and women laboured in the same industry or alongside each other doing the same work, women would be paid less. In other instances, women were excluded from the higher paid roles, or the role designations for men and women drew artificial distinctions. Some basic examples: a seamstress earned less than a tailor. A cook earns less than a chef. And so there were a lot of more complex designations and awards which made quite severe distinctions, but actually the content of the work of the job was fairly similar. Even in 1972, women were seen as secondary income earners, and a man needed to be paid enough to support his wife and children, whether he had them or not, of course. The arbitration court developed the concept of the family wage, and that was what a man needed to be paid to support himself, a wife and 3 children in reasonable comfort. This was never accurate or fair as a distinguishing feature, because historically and now, women have often been primary or only income earners with children to support. The Equal Pay Act put in place a 5-year period for the gradual removal of gendered pay differences for the same work. The Act also required employers to set a pay rate without a distinction based on gender, so without discrimination, for work exclusively or predominantly carried out by women. So where you didn't have men and women doing the same job, so you weren't comparing apples with apples, but where you had almost exclusively work done by women, such as the cleaning, the cooking, the caregiving. Where there were no men doing a job, or there were very few to compare with to see whether there was gender discrimination in pay, the employer was required to pay the rate of remuneration that would be paid to male employees with the same or substantially similar skills, responsibility and service, performing the work under the same or substantially similar conditions, and with the same or substantially similar degrees of effort. So essentially looking beyond the designation of the job or who had traditionally carried it out, but actually looking at what does it take to do that work, what skills, what competencies in common parlance. Now we would talk about competencies, what sort of effort is involved, how difficult are the conditions, what's the physical labour involved, what's the mental exertion involved, all those, what is actually involved in this work, and then comparing the rates. So you would look at, if there aren't any men doing it to compare you with, what would it take if we looked at break that job down into its constituent nuts and bolts. What should that job actually be worth if you strip out the gender factor? Unfortunately, the mechanism for working this out, for implementing this aspect of the Equal Pay Act, was not spelled out in the Act, as it was seen by the Commission as too complex to devise a one-size-fits-all way of comparing a new kind of like with like. The implementation was essentially left to the market. To the subsequent dismay of some people involved in the Commission and later reviews of the implementation of the Act, the market did not deliver. Proponents of equal pay for work of equal value, which now we would call pay equity, tried and failed to convince the courts in the 70s and 80s that achieving fair pay rates in work dominated by women meant finding a suitable comparator unaffected by hidden assumptions about the lesser worth of women's work. So equal work, equal pay arguments were simply rejected. It was, no, that's not what this Act means, even though it is specifically spelled out in the legislation that that is what it is also meant to apply to. And as I said before, The Australian approach excluded that. I'm not sure whether I did say that, but the Australian approach excluded women's work predominantly carried out by women. The employers' lobby had urged the Commission to exclude that work of the work predominantly carried out by women from equal pay coverage. And the Commission said no, we are simply not prepared to accept the fact that this huge sector of our employment market, women in these traditional women's roles, the majority of women in New Zealand, and still is the case, we're not going to sweep them under the carpet and say, no, equal pay doesn't apply to you. So they expressly rejected that. The courts, however, seemed unaffected by those arguments, and so people ended up trying to run these cases and being knocked back over and over again. In terms of how to do those sorts of evaluations and comparisons, a great deal of expertise and data now exists to undertake such evaluation exercises, and the court accepted in the Dyhrberg case that I'm going to talk about that wasn't an impossible exercise at all. There are quite sophisticated models now in existence and a lot of research and data both in New Zealand and overseas to say this is how you compare apples and pears rather than apples and apples. The example it's often given, so I'll give you the sort of, given the rule of thumb kind of example of what I'm talking about, of a suitable job evaluation exercise is to compare the pay and conditions of, say, nurses and firefighters or nurses and police. And what you do is you look in a gender-neutral way at what the jobs actually entail, as I said before, breaking it down to the nuts and bolts of what this work entails. The extent of training and skill, physical effort, responsibility for the safety and well-being of the public, and the risk of personal danger involved are similar in those roles, but nurses have always earned less than those traditional male roles. The explanation for this, when you take away all of the factors and the adjustments that you have to make for genuine difference, is that you're left with a hidden bias based on gender. Another example was in one equal pay case, a woman measuring out curtain fabric earned much less than a man in the same store measuring out carpet. Essentially, the man's job was assessed as skilled and the woman's job was not. So that's the sort of cases that were happening, and they were getting knocked back. After a particularly brief but firm rebuff in the 1986 farmers' trading case, the equal pay lobby essentially gave up on the courts because the door was shut very firmly in their faces. And they tried for years to implement better legislative provisions to make this equal pay concept work, to provide the mechanism. Measures came and went as governments changed. The Equal Pay Act remained on the statute books. It was never ever revoked or repealed, and each subsequent piece of legislation, the Employment Contracts Act, the Employment Relations Act, and amendments have always preserved the Equal Pay Act. It never went away, and it was never forgotten. I went through my first years of employment law telling people what we were all told, which is, well, the Equal Pay Act's only useful if you've got firm evidence that the guy next door with the same qualifications and experience is being paid a lot more than you. Until you've got that evidence, there's really not a lot we can do about it. A lot of people never gave up the faith, and that resulted in the Bartlett case, the Dyhrberg case, being heard last year. Almost a year ago, the Employment Court held in favour of Ms Bartlett and her union. The court accepted that women in caregiving roles were being paid far less than their work would have been worth had it not been traditionally female and therefore undervalued. The court noted, by way of an illustration of the inherent inequity in the sector, that the male gardeners working for Terra Nova earn substantially more per hour, about $3 to $5 an hour, more than the predominantly female caregivers, despite the caregivers' greater responsibility and competencies. I think I put it as, surely cutting grass and looking after the rose bushes cannot be nearly as skilled and responsible as looking after people. And that was accepted, I'm pleased to say. I then incurred the wrath of the union movement because they pointed out that their gardeners weren't paid enough either. But they were still paid a lot more than the women. As Ruth Dyson once put it on Suffrage Day, it is a triple whammy where workers are undervalued because they are primarily women, the type of work they do is undervalued, and the older people and people with disabilities they care for are also undervalued. To address the situation, the court held that suitable comparators have to be found outside that artificially depressed caregiver role and maybe even outside the sector. The ruling has been appealed to the Court of Appeal and has been heard, and we are waiting the judgment now. And I am moving to my last section, so going a little over time, sorry. The finding is extremely significant for women who work in caregiving roles in the rest home sector. There are approximately 33,000 workers in this sector and 92% of them are women. Most are paid at or are very little above the minimum wage, even after decades of service. If the findings of the Employment Court survive the appeals process, this will be a legal precedent of much wider application, however. It will be open to women in any sector to apply for an assessment of their pay rates, and if they can establish that those pay rates have been artificially depressed by a female aspect, then they will be able to challenge that and get a proper assessment made. As I said, in New Zealand, the majority of women still perform traditionally female-dominated work, so the scope of this is quite significant. Across Western economies, there's still a significant gap in the earnings of men and women. In New Zealand, it's still around 80 cents. That hasn't changed a lot over the years. After you adjust for all rational explanation for the difference in the pay of men and women, there's still about a 12 to 14% gap that is still unaccounted for. So that's the gender pay gap that people talk about. It impacts on highly qualified professional women within the first 5 years of employment. There is a significant gap and it simply continues to widen over time. But the women who are suffering the most because of gender discrimination is obviously the women at the lowest step of the economy, women on or near the minimum wage. Many of them are in insecure part-time work or in casual employment. This disproportionately affects Maori, Pacific Island and other ethnic minority women. When surveyed, most of the women in part-time work would like to work more hours, and people who are casual usually would like to be made permanent or have more job security. These women are more likely to be working several jobs to make ends meet, and they find it incredibly difficult to climb out of working poverty, and that's what we're talking about, the working poor. Getting to the next rung on the ladder and increasing your earning potential is simply impossible when you're just scraping by. You haven't got the time or the money or usually even the self-confidence to go and gain qualifications. And this is an important social justice issue. It's not just a women's issue. This directly impacts on the well-being and prosperity of not only women but their families. And often men and women in these families, you'll see they both work for the same company or in the same sector. They'll both work in these low-paid cleaning jobs or in catering jobs or whatever it might be. A lot of these women are sole parenting, and the proportion of households headed by women across the world is growing every year. I'm told that's how Barack Obama actually got elected the first time. He appealed to that market sector. 25% of New Zealand children are living in poverty, and while a lot of those children are the children of beneficiaries, a lot of them are the children of these women, of the working poor. So if we address the unfair devaluation of the work women do, that will have a direct and significant impact on improving the standard of living of not only the women but their families and their children. And a lot of them are raising their grandchildren, and a lot of them are supporting male partners or a wider family. So we're talking about raising the living standards not just of a bunch of women but also of a whole sector of society, and that can only be good for everyone, in my opinion. So the Bartlett case is an example of what can be achieved when a group of extremely determined and stubborn people, who I am very, very proud to call my friends, decide to challenge the way things have always been and to keep asking why. Why has it always been that way? Why is it okay, and how can we change it? The women of the Coalition for Equal Value, Equal Pay didn't give up, even though it took over 40 years to get a real hearing of the issue in a court. And some of the women involved in that case and in briefing our firm had been involved right from the very outset, from the Commission of Inquiry and onwards. And my last thing I want to say to you is that this issue of addressing the gender pay gap generally, gender issues in the workplace, is firmly back on the agenda if it ever went away. And I've recently read this fantastic book, which did win an award when it first came out. It was shortlisted for the Business Book of the Year. It's a book by a woman called Sheryl Sandberg, who is the Chief Operating Officer of Facebook, who's got an illustrious commercial career, and it's called Lean In. I would very strongly recommend this to every manager, man or woman, everybody who runs a business, owns a business, and has a significant interest in developing the talent in their organisation and growing future leaders and in maximising profit, because Sheryl Sandberg knows what she's talking about, and she makes some fantastic suggestions and talks about real stories about how to grow the talent pool and increase competent female leadership and the benefits, the tangible benefits that has not only for those women, for other women, and for the businesses themselves. So I'd strongly recommend Lean In by Sheryl Sandberg as a bit of a how-to guide on how to tackle these issues in your workplaces. Thank you very much for having me today and letting me talk about something that I care about a great deal. I know I've probably run over time, but if there are questions, I'd be happy to take them.